Well, good evening, everybody. For those of you who don't know me, my name's Jane Bickerstaff, King's Counsel, and I'm Head of Crime at 9BR Chambers. And I'd like to welcome you all, and indeed everybody, there's a lot of people online as well, to this 9BR Crime Team lecture. It's the first in our series of autumn lectures, and we are absolutely delighted to be able to hear from Max and James about their involvement in the case of Andrew Malkinson. I'm sure all of you know that Max Hardy is a member of Chambers who was junior counsel on this case. And let me just introduce you, for those of you who don't know him, to James Burley, who works as an investigator for Appeal, which is a charity and law practice dedicated to fighting miscarriages of justice. And he worked closely on this case. Indeed, Max tells me he was the person who knew the most about it and worked the hardest of anybody. And before he worked at Appeal, James interned at a non-profit law practice in Louisiana, working on death penalty cases. I think that there's probably no case in the recent past that captured the hearts and minds of the British public quite like the Andrew Malkinson case, an astonishing miscarriage of justice. Just to put matters into context, very briefly, because no one's come here to listen to me speaking, but the offences of which he was convicted took place in July of 2003. He was convicted in 2004. His appeal against conviction was dismissed by the Court of Appeal in 2006. And the Criminal Cases Review Commission twice refused to refer his case back to the Court of Appeal, firstly in 2012 and then in 2020. And of course, his convictions were finally quashed by a judgment that was released on the 7th of August of this year, but not before he had served 17 years for crimes that he undoubtedly did not commit. And of course, it was very well covered in the press. I'm sure you'd agree, with details that made the nation collectively gasp in astonishment. For example, that those who are in the position of Mr. Malkinson, spending so many years wrongly incarcerated, were expected then to repay for the board and lodgings they had had. But what was not so well covered in the press was the length of time that this took, the tenacity and persistence of Max and James, together with Ed Henry, King's Counsel, in the face of closed doors, refusals and delays. And today, this evening, forgive me, we're going to hear from Max about the things that went right through that process, and from James about the things that went wrong. So, as I say, excuse me, nobody has come here to listen to me. So without further ado, I will hand you over to the indomitable, indefatigable Max Hardy.
I'm very grateful to Jane Bickerstaff KC for that introduction. And as you will know, those of you in the room and also online, what James Burley and I are going to be talking about in relation to the Andrew Malkinson case is what went right with it and also what went wrong. And something I want to say from the absolute outset, it is, in my view, an incontrovertible reality that there are other Andrew Malkinsons out there. And I hope that what this case will do, and it's in its own very small way, this lecture this evening will do is put out a message as to what needs to be done to expose those cases and bring justice, however belatedly, to them. There is a bit of a common thread as to how I personally came to be involved in this case, because like James, I also have a little bit of a death penalty background. I met Emily Bolton, the founder of Appeal, in New Orleans, Louisiana, 2004, when I was out there working on post-conviction death penalty cases as an intern. And although I didn't, in fact, work with Emily out there, a connection was made. And ironically, it's a connection that came to fruition 3 years ago when she brought me into the case, of all things, to bring a prosecutor's perspective to it. But one thing I want to say about the death penalty in connection to this case is that this case could not more fully vindicate, to my mind, the fact that the death penalty is a totally unnecessary form of punishment, and this case could not more better exemplify how fortunate we are to have abolished it in this country. But as I say, I was brought into the case to cast a prosecutor's eye over it, and that perhaps answers one of the first questions that I've been asked about this case is, well, how did you come to be involved in the first place? And I was asked to provide a second opinion on what were relatively recently discovered previous convictions of what had been described at trial as two independent eyewitnesses to this offence. And I was asked to give an opinion as to whether at trial that conviction history would have been admissible. And so I had a look at the case. I was given only very limited access to the papers right at the beginning. But what I could immediately see was that this was the wrongest case I'd ever seen in my entire career. I mean, it just jumped out from the page how wrong the case was. I'm bound to say that if I had known back in 2020 that the case would not conclude for 3.5 years, I might have given a moment's pause to becoming more fully involved. But in reality, I knew this was the case that I had to see through to its end. And I'm extremely glad that it was not a bitter end in Andrew Malkinson's case, however bitter at the start of it was for him. And then another question that I'll deal with is often posed in what is generally referred to as miscarriages of justice. It's an expression that on a personal level I don't like to use. I prefer the expression wrongful convictions, because I take the view that in a case like this, it was a conviction that was full of wrong. And sometimes the expression miscarriages of justice can create the impression that it's just bad luck or one of those things that brought about what went awry. And in my view, in Andrew Malkinson's case, as is quite often the case, when things like this come to light, things have gone wrong. And it's very important to say things have gone wrong here and to acknowledge that and do what we can to rectify them for the future. But a question that very often gets asked, well, if Andrew Malkinson had absolutely nothing to do with this at all, how did it come about that he was in the firing line? How did he end up in the frame? And the very short answer to that question is, we don't know why the police preferred him as a suspect in this case. We do know that his name was put forward as possibly matching a description given by the victim of her attacker. We know that the officers had put his name forward, had stopped him on the back of a scooter a few weeks before. And we know that they went to his workplace. And one of the things that they established was that there was no sign on his face of a very significant scratch, which the victim could not more clearly have said she gave to the man that attacked her. And yet, despite that, the police pursued him. And Andrew Malkinson would like to know why. An appeal on his behalf remained determined to find out why. The small, if I can call it this, take home that I'd like to offer from the get-go is this, and any of us that practice in crime will know how dangerous identification evidence can be. But this case could not more strongly exemplify quite how dangerous that type of evidence can be. There are other types of evidence that, in my personal view, are yet more dangerous. I don't have much trust for lie detector evidence, not currently admissible in criminal proceedings in this country, and nor for cellmate confession evidence or psychological profiling, anything like that. But pure identification evidence is extremely dangerous, and that's something that the Court of Appeal has acknowledged for a very long time. And this case simply reinforces that fact. And it may be that for the future, convictions that depend entirely on identification evidence, as Andrew Malkinson's did, will become few and far between. CCTV is now so ubiquitous, cell site evidence, these other strands of digital evidence that mean that it's now a very rare case where there is identification evidence and really and frankly, literally nothing else. But that doesn't mean that we shouldn't treat ID evidence with any less caution. So as I say, we're going to be talking about what went right and what went wrong. And it's absolutely the case that things did go right. However, belatedly, as I've said, regrettably, a list of things that went right is rather shorter than a list of things that went wrong. But in my view, it's nonetheless very important to acknowledge where things went right in this case, because contrary to popular opinion, I don't take the view that you can only learn from things going wrong. So I'm going to comment a little bit about what, in our view, did go right in this case. And it's absolutely proper. The first thing I say in relation to that is we had the right client. And I don't mean that in a flippant way, because anybody that has heard Andrew Malkinson speak in the media can hear and see for themselves what a man of quiet and reasonable fortitude he is and was. He is somebody who could have, at any moment over many years, have chosen the path of expediency over what he knew to be the truth, which is that he had nothing to do with this. And by sticking to his guns and sticking to his principles, he spent up to 10 years longer in prison than he otherwise might have done. And so that is a real testament to him as a person. And anyone, as I say, who's heard him speak can see that he even has sufficient empathy to realise that he is not the only victim of this particular miscarriage of justice, because of course the victim herself, no doubt for all this time, thought that she had achieved justice. And I want to say something briefly about having Andrew Malkinson as a client, because it's right to acknowledge here that the way in which Appeal cared for him, both in a literal sense of the word, but also as his lawyers, was something really remarkable to be seen. And I don't think anybody can or should underestimate what a psychological toll an experience such as one he has had would have on somebody. And I've seen firsthand how much care Appeal took for his well-being following his release. The next thing I want to talk about going right for him is what I refer to as fighting on all fronts, because the range of institutions, organisations, and lines of inquiry that Appeal undertook on his behalf is really, frankly, head-spinning. We obviously had to interact with Greater Manchester Police, Crown Prosecution Service, the IOPC, the CCRC. We had to launch judicial reviews. We had to search court records and newspaper records. Site visit was undertaken. in-person witness inquiries undertaken, subject access requests, freedom of information inquiries, and trawling of social media. And it has been an absolutely gargantuan task, as I say, fighting on all fronts. And that follows into the next thing, and it's absolutely critical if you're going to prevail in this kind of appeal, and that is defence investigation. And it's something that's much less fashionable in English jurisdiction than in America, where Emily Bolton learnt the ropes. And notwithstanding the police obligations to investigate cases impartially and objectively, the reality of the situation is that nobody's going to investigate a defence case as well as a defence. And here I'm really going to pay tribute to James Burley, who, as Jane Bigstaff has already said, certainly in my view, knows more about this case than anybody alive, and has been living and breathing it for, is it 5 years? 5 years. And the old truism, if you want something done, do it yourself, could not apply more than in a post-conviction appeal situation. The next thing that I want to remark on as having gone right in this case, but only, frankly, by the skin of our teeth, is the preservation of scientific samples. As I'm sure most, if not all of you will know, the Crown conceded the appeal in the end on ground one, which related to the discovery of the identity of the DNA of a known person on the victim's clothing. And the only reason why that DNA discovery was possible was because scientific samples were preserved at the laboratory. And actually, there was a very interesting article in The Guardian a few weeks ago querying the real risk to the preservation of scientific samples, given what is going on in the forensic science field at the moment and the funding that goes to it. Because if those samples had not been preserved at the laboratory, I would be prepared to bet my house that Andrew Malkinson's conviction would never have been quashed. And that is because physical evidence in this case was destroyed by the police on 3 occasions in what's been referred to as a weeding exercise. And that included clothing belonging to the victim. And so that meant that the actual hard, real evidence in the case was not susceptible to ongoing testing because it no longer existed. And as I say, the fact that samples were preserved at the laboratory made all the difference. And so certainly this is an appeal to go out to the importance of the preservation of samples, but also very obviously that when a case is subject to ongoing appeal, and Andrew Malkinson's been challenging his conviction from the moment the guilty verdicts were returned, the police absolutely have no place in destroying any of the evidence at all. And it is a matter of real concern in his case that that destruction process took place, and it's high on the list of things that he continues to look for answers to. The next thing that I'm going to broach is asking for help. I'm sure it's already obvious, but mounting an appeal like this, it is a team effort. It is absolutely not the work of one person, however invaluable and critical James was to the exercise. And asking for help really can extend far beyond either a barrister's chambers or a solicitor's firm. And I just want to make mention to some of the many organisations, people that were involved in one way or another with pursuing this appeal. Ropes and Gray, Latham and Watkins, Mishcon de Rare, Morrison, Forster, Professor Christophe Champod, Franco Tironi, forensic scientists. And that is not quite a cast of thousands, but it is a very, very significant array of legal and scientific firepower. And you may think if you're sitting there in the capacity of, for example, a high street firm of solicitors, you're trying to keep your head above water, how on earth that you would pursue a case like this. And I really want to emphasize that there are some very, very well-resourced firms and entities out there that get involved in this kind of work. And you've got to put the appeal out and you've got to enlist their assistance. And I can tell you when they bring that assistance to bear, it really means something. I asked James if he was able to say how many hours appeal has spent on the case, and his estimate is that this was 3,000 hours of work by appeal, and that is just appeal, because that doesn't include, and I'm going to come on here, and perhaps in one sense this is a first name that I should have acknowledged in the context of Andrew Malkinson's appeal, and that is of my leader, Edward Henry, King's counsel. Edward was also, many years ago, my pupil master. And when the case was referred, the Court of Appeal granted a certificate for leading counsel. He was absolutely at the top of the list of names that I suggested to Emily Bolton as being somebody that could really take this case on. And anybody who has watched any of Edward's submissions in the Court of Appeal can attest for themselves. He really delivered the goods when it mattered. And I really want to emphasize on his behalf that that was not a matter of chance or a fluke. That was serious hard work and preparation, and a lot of mooting went into the preparation for the appeal in this case, because when you're taking on a case as sizable and as significant and important as this, you want to be ready for anything. And James spent many hours with Edward firing at him the kind of questions that we thought might come up in the appeal itself. And talking of the appeal itself, I'm now going to comment on the appeal and the Court of Appeal, and something which I think was absolutely commendable about the Court of Appeal's handling of this case. And I've talked about anybody that's watched any of the submissions, because the entire appeal is available to watch on YouTube. And to my mind, that demonstrates exactly the kind of commitment to open justice that we should all be welcoming and encouraging. And if you're a law student, for example, and you don't have the time to get yourself down to the Royal Courts of Justice, or you missed the hearing, you can watch it all on catch up. And I've been really quite taken aback by the number of barristers who come up to me in roping rooms who've said either they've watched part of the appeal in their own time or even the whole thing. And it's really clear that there is an audience for this out there. And in days where people perhaps don't have the time to get into a very physically limited public gallery, it's very encouraging to me that that hearing is available for all the world to see in their own time and in their own comfort. And then in relation to the court's handling of the case itself, something which gave certainly James and me an enormous amount of anxiety in the months leading up to the appeal, it is whether this would be written off, and I don't mean that dismissively, but characterized as simply a DNA case, because there was always that possibility. That was the prosecution's stance of the appeal, that the conviction was rendered unsafe by the fresh DNA evidence, but not unsafe for any other reason. And I always took the view that the DNA evidence in this case provided the way out of what has been an absolute nightmare for Andrew Malkinson, but it gave no understanding of what brought it about in the first place. And the fact that the court acknowledged that grounds 2 and 3 were made out as well was very heartening for us. It was heartening for Andrew because it was an acknowledgement by the court that this was a conviction that was unsafe because of what had transpired at the trial itself, not just because some other person's DNA had turned up on analysis many, many years later. I'm going to say something now about media, because true crime is now an extremely popular brand of, and I certainly don't want to dismiss Andy's case as entertainment, but Emily Dugan, the investigative journalist, produced a podcast on this case, which meant that anybody taking an interest who was not, in fact, intimately involved in the case could nonetheless glean for themselves an understanding of the narrative and what went on. And I haven't even tried for 1 second to give the narrative of the case before you this evening because it is a colossal narrative. And it's important that I also mention Bob Watkenden here, 2016 published a book called The Nicholas Cases, Casualties of Justice, and commented on Andrew Malkinson's case back then as being, in his view, a clear and demonstrable miscarriage. And so in terms of pursuing appeals now, the media can be very helpful. Of course, one has to approach the media with caution, not least for contempt reasons, but also because of course, the media have got their own agenda, but it is naive to overlook its power as an ally in bringing miscarriages of justice to light. Another thing that has gone right in this case, and I think all of us have been, quite frankly, taken aback in its aftermath as to not only how much it captured the public imagination, but also that it has triggered, again, however belatedly, official inquiries. And I particularly want to remark upon that commissioned by the Lord Chancellor Alex Chalk, the anxiety that he expressed in relation to the missed opportunities to expose this miscarriage of justice as potentially the CCRC marking its own homework in relation to its handling of the case. And really just on a very basic level, he picked up the telephone and spoke to Andrew Malkinson on the phone about the case and his intention to launch an inquiry. And it may seem like the most obvious courtesy in the world, but it's not a courtesy that was extended to Andrew Malkinson by everybody who's been involved in his case in the past. Something else that went right with the case, certainly by the time the appeal came around, is the marshalling of fact and law. Again, perhaps it's a statement of the obvious if you're a lawyer. You have to deploy the law, but there's no point turning up at the Court of Appeal and saying, well, I've got some very good facts here, without being able to substantiate the validity or virtue of those facts if you can't demonstrate their legal grounding. And likewise, there's no point just having the law at your fingertips if you can't point to the evidence that casts doubts on the safety of the conviction. And it was one of the things, in my view, is Ed Jr. That was so impressive with his handling of his submissions was the way that he was able to weave the law into his submissions about the evidence in the case. And then the last thing I'm going to say before handing over to James, and frankly speaking, the great deal more that could be said about what went wrong in this case, is an acknowledgement of pure luck. And it's often said you make your own luck. And I feel in this case, the sheer quantity of effort that went into the appeal perhaps had something to do with the stroke of luck that meant that this person's DNA on the victim's clothing was that of a known person. Because again, if that had not been the DNA of a known person, in my view, CCRC would not consider that to be a basis for referring the case back to the Court of Appeal. I would add, erroneously would have formed that, but the fact that it was a known person made all the difference. And I think it's important to realise that sometimes you just do need a bit of luck on your side, even if Andy would say that he was perhaps the unluckiest man in England back in 2003 when he was arrested, 2004 when he was convicted. But anyway, those are my observations about what went wrong in the case. I'm now going to hand over to James and say he's going to talk to you about what went wrong.
Thank you, Max. Thank you all for coming. So I just wanted to start by endorsing a couple of things that Max said. The first is the tribute he paid to Andy's strength and determination, because however long we've been fighting it as Andy's legal team, he's been fighting this for 20 years and he's still fighting for justice and for answers. So I think that's absolutely right to say. And then the second thing is, as Max said, it really took a small army of people to overturn this wrongful conviction. Anyone who's worked on these kind of cases will know that it's not easy. And, it really did take, my colleagues at Appeal in terms of the casework, but also supporting Andy, all of the pro bono firms who put in so many hours. And then Max and Ed, they worked really collaboratively, they really collaborated with us, and they spent hours and hours preparing this. They took it really seriously and gave it the effort it deserved, and that really paid off because, as Max said, we were concerned that it would simply be treated as a DNA exoneration by the Court of Appeal, and actually the point is this conviction was unsafe from the get-go. So I'm here to talk to you about the failings in the case, and the truth is that so much went wrong in Andy's case that there's no way that I could possibly cover them all this evening. So I've just chosen 6 different failings, which I think maybe offer some broader lessons for the criminal justice system. So the first of those is the police investigation on what went wrong right off the bat. Then the identification procedures, and this was a case that was dependent entirely on ID evidence, but those procedures weren't carried out correctly, and yet the jury were allowed to hear that evidence and convict Andy on the basis of it. The next thing is material non-disclosures. So, Andy was deprived of evidence which should have been handed over to his defence team, and the result of that was that he was denied a fair trial. The next thing is something that isn't often really questioned in this country, but it's to do with the majority jury verdicts. So the jury was not unanimous in Andy's case. 2 of the jurors back in 2004 did get it right and voted not guilty. But obviously he was convicted regardless on 10-2 verdicts, so I want to talk a bit about that. The next thing is really what went wrong after Andy was convicted, why it took so long for him to get justice. And that's really divided into the failings of the safety net that our justice system has. It's not really a safety net, that's exactly the problem. But the Criminal Cases Review Commission, as Max alluded to, twice turned down Andy's case. And I want to talk a bit about them. And then lastly, the difficulties we had accessing disclosure on the case and how hard it is for people to who are seeking to prove their innocence to access exculpatory evidence that's held by the police. So the first of those failings is the police investigation, and really from the get-go it suffered from what's called tunnel vision. Effectively, Andy became a suspect on the hunch of a couple of police officers, even though he didn't match the victim's description in some really significant ways. The height didn't fit, the accent wasn't right. He had hair on his chest where she had described a hairless attacker. And most significantly, the victim said that she had managed to inflict a deep scratch on her attacker's face. Andy was seen the next day by police and had no trace of any injury like that. And that really should have been the end of it. Instead, and despite the fact that there was no forensic evidence pointing to Andy's guilt, they persisted with him as their main suspect and ignored other lines of inquiry. And there were many names put forward by the public, including individuals with previous convictions for rape, which weren't properly followed up. And I think the broader lesson here is something that Max touched on, which is defence investigation. In this country, the CPIA Code of Practice requires that police officers investigate all lines of inquiry, whether those lead towards the suspect or away from the suspect. And I think there needs to be a conversation about how realistic that is, because ultimately we have an adversarial system, and when the police think they have their man, it's very hard to believe that they'll investigate alternative explanations. And in the United States, most public defender officers will have their own in-house investigators. They consider it effectively naive to leave the investigating just to the police. And there needs to be some thought given to resourcing defence investigation here, because obviously under the current legal aid system, you haven't really got much chance of hiring an investigator for your case. But it's something that needs to be looked at. The next thing is the identification procedures. So, as I said, the case the prosecution case depended entirely on evidence, identification evidence, which came from the victim and a couple who were called Michael Seward and Beverly Craig. They left their homes at 4:15 a.m. in the morning for reasons which the court appeal later sort of commented, but not very clear. And they claimed to have witnessed the lead up to the attack. And they came to court and said they were absolutely certain that they'd seen Andy out that night. All three of those witnesses were participated in video identification procedures, but those procedures were not carried out in accordance with the rules that govern them, which is the Police and Criminal Evidence Act Code, Code D. And there's some really significant breaches. So first of all, the victim and Beverly Craig were transported to the identification procedure together. Witnesses are meant to be kept apart to avoid any possibility of contamination. The next thing is that there's meant to be contemporaneous record keeping of ID procedures. And Beverly Craig, who later came to court saying she was absolutely sure she'd seen Andy, actually didn't pick out Andy during the ID parade. She picked out somebody else, and then later claimed that she had a conversation with the officer who was escorting her out, where she actually said, "Oh no, I meant to pick the position which Andy was at." That officer didn't make a note of that conversation, that alleged conversation, and she wasn't asked to formalise it in a statement. And that obviously should have been documented. The next thing is that ID procedures are meant to take place as soon as possible after the sightings. But Michael Seward actually didn't take part in the procedure until about 6 months after his sightings, which lasted a matter of seconds and were made at night from a moving vehicle. And he picked out Andy and was allowed to come to court and say he had absolute certainty of his identification. And the defence tried to exclude Michael Seward and Beverly Craig's identification evidence. They were unsuccessful in that. And so you had a situation where a case that was entirely dependent on weak and flawed identification evidence and unsupported by forensic evidence, by CCTV evidence, by cell site, bad character, nothing else, that was allowed to be put before the jury, and they were allowed to convict Andy on that basis. I think there needs to be some thought given to what the point of having a code of practice is if, when it's breached, there are no consequences or implications, and also really whether we should be allowing juries to decide the cases dependent entirely on identification evidence in an era when we've got more and more sensitive forensic techniques. And yeah, it's just a case that really should never have been put before a jury. The next point is the material non-disclosure, the fact that the jury were effectively deprived of evidence that they should have heard and were misled on really key issues. And this is something the Court of Appeal obviously found in its judgment, was that Greater Manchester Police had withheld material from the defence which could have altered their verdict. So that material which GMP failed to disclose was firstly some photographs. It's a bit complicated to explain, but you have to remember the key defence point in the case was that Andy didn't have a scratch. And the police had failed to disclose photographs which contradicted some medical evidence that had been read to the jury, which was relied on by the trial judge to effectively cast doubt on whether the victim was correct in her recollection that she'd scratched her attacker. And so that non-disclosure effectively deprived Andy of the full force of his strongest defence point. The next thing was the previous convictions of Beverly Craig and Michael Seward. So they were presented as honest witnesses. The defence even conceded that they were honest. But in fact, they both had criminal records. They both had convictions for offences of dishonesty and deception. Michael Seward also had convictions and portions for drug offences. He was a heroin addict, and that information was not disclosed to the defence, even though the defence had actually made an explicit request for the previous convictions of all civilian witnesses. The other thing that was not disclosed by the police were records which showed that Michael Stewart and Beverly Cake's story of simply coming forward to the police out of a sense of civic duty might not actually be the full picture. So we managed to establish that Michael Stewart had actually been arrested on the date that they came forward to police as witnesses. He'd also been arrested and taken to court on the date that he, 6 months after these alleged sightings, picked out Andy, the ID procedure. And what we also established was that after he picked out Andy at the next court hearing, some of those charges that he faced were withdrawn. So none of this information was disclosed to the defence, and the result was that the jury were just fundamentally misled about the key evidence in the case, the ID evidence. And I think the lesson here really is that the regime we currently have governing disclosure, the Criminal Procedure and Investigations Act 96, time and time again there have been reviews which show that it's not working very well. Disclosure failings are lamentably common in our justice system, but none of these reviews have really questioned whether the system itself is inherently flawed. And one of the things that's inherent in the system is that it places a lot of trust in the police. The police effectively get to decide what the prosecution gets to see, and thereby they have power over what the defence gets to see. Now, in an adversarial system, we really trust the police to be faithful gatekeepers to the evidence. Are they really best placed to know what might undermine the prosecution case or assist the defence case? And can they really be trusted to hand it over? I think those are all questions that really need to be looked at. The next point is the majority verdict that Andy was convicted on. So it was a 10-2 verdict. There were two jurors who, as I said, had it right. And it's worth reflecting on that because in the United States, that wouldn't have been enough to see Andy convicted and sentenced to life imprisonment. She was. There are only two states that ever had non-unanimous verdicts, Louisiana and Oregon. And in 2020, there was a case, Ramos, in which the US Supreme Court ruled that you couldn't be convicted of a serious crime unless the jury was unanimous in its decision. And it's really interesting because in this country, in England and Wales, majority verdicts are actually a relatively recent phenomenon. They were introduced in 1967, and the reason that was ostensibly given was concerns around jury nobbling. But my colleagues, Nisha Waller and Naim Sakande, in some research that I think will come out at the beginning of next year, they've been looking into the origins of that really fundamental change, and have established that essentially those concerns around juries being interfered with was overblown, and that actually racism and classism played a big factor in the introduction of majority verdicts. If we really believe the kind of legal maxim that it's better that 10 guilty persons go free rather than one innocent suffer, then I think we really need to think about the protection that unanimous verdicts provides for innocent people like Andy, and return to a system that we had for hundreds of years. And only recently abandoned. And I think that Andy's case is not the only wrongful conviction case that involves a majority verdict. You have the Oval Form case of a man called Michael Burley. I think in the Tudor Ford case as well, there was a majority verdict. There's an absence of data on this, but I'm pretty sure that you'll find in a lot of wrongful conviction cases, not all the jurors were convinced. So after Andy was convicted, the failings rumbled on, and as you know, it took 20 years for him to finally clear his name. That was 17 years in prison for Andy, 2 judicial reviews, 3 CCRC applications, 2 trips to the Court of Appeal to finally get him the vindication he deserved. It really should not have taken that long. And the fact that it did is an indictment of the criminal justice system, and in particular, the Criminal Cases Review Commission, which is a statutory body that was set up in the wake of the Birmingham 6 cases and some of the other high-profile cases to investigate miscarriages of justice and refer any back to the Court of Appeal. Andy first applied to the CCRC in 2009, and they really could have resolved this matter then. but they didn't. And the key failings there were really that they didn't bother to obtain the police file of the case. And if they'd done that, they would have uncovered the non-disclosure, which, as the Court of Appeals ruled earlier this year, was enough to get his conviction overturned. The second thing was that they were presented with the results of some DNA testing that had been done. And that DNA testing showed that there was another male's DNA in an area on the victim's clothing, which the prosecution, in a memo that the CCRC actually had seen, described as crime specific. The CCRC, even though all of the potential innocent sources of that DNA had been excluded, and the dog walker who called the police, the paramedics, the victim's partner, they said that that didn't matter, and that wasn't enough to justify referring the case back to the Court of Appeal. They felt remarkably that it didn't undermine the very strong ID evidence against Andy. The other thing that the CCRC did in that first review was they refused to conduct any of their own DNA inquiries. So they simply stopped investigating. This is despite the fact that the DNA that had been detected was actually searchable. So eventually, as Max alluded to, a man was identified. That was late last year in 2022. But his DNA profile had actually been sitting on the database since 2012. That intervening decade, the CCRC didn't bother once to arrange a search. And if they had done, not only would they have saved Andy a lot of wrongful imprisonment, but they would have potentially identified this suspect sooner. Why is it that these failings occurred? Well, it's not a resources issue. I think that the CCRC does need more funding, but the issues are a lot more deep-seated than that. The first thing really that comes out of Andy's case is that the CCRC doesn't approach cases always with an open mind, and they don't really show any curiosity. The case record that we were able to obtain from Andy's first review showed that his submissions, his application was literally met with amusement by the CCRC. It didn't countenance the idea that the jury might have got it wrong and that these three ID witnesses might have got it wrong. And so I think effectively they didn't believe him. They didn't bother to investigate, to see if any evidence had been withheld, to see if another suspect could be identified. I think linked to that failure to really do their jobs is the leadership of the CCRC, because the leadership does set the tone for most organisations. And we currently have a situation where we have a part-time chair, Helen Pitcher, who's got 8 other jobs, including running her property business on the side. And as Andy has said, the CCRC's current leadership is just not serious about miscarriage of justice. And that's something that certainly needs to be closely looked at. The last thing really is accountability, because the reason that the CCRC is able to get away with the kind of shoddy decision-making it showed in Andy's case is because there's no real effective mechanism for challenging their decisions. Your only option is judicial review, which is extremely costly, it's expensive, it's complex, and it sets the bar very high. It's not enough to simply show that the CCRC's decision was wrong. You have to show it's unlawful. And given that more than 95% of applicants to the CCRC don't have representation, judicial review doesn't offer them any kind of prospect of accountability. And I think that lack of accountability has allowed these issues of the CCRC to kind of fester. And that explains why you had so poor decision-making in Andy's case. So I think the CCRC really needs a complete overhaul. They need new leadership. Helen Pitcher has not even apologised to Andy in the wake of his exoneration, despite 150,000 people now signing a petition calling for that. And yeah, we need some accountability as well, and the CCRC simply needs to have the drive to actually investigate cases thoroughly. The last thing I want to talk about is post-conviction disclosure. So obviously we were eventually able to uncover the exculpatory evidence that had been withheld by the police, but it took a huge amount of work. It took 2 judicial reviews, and frankly, it took a lot of luck. And the reason why really is because the law on post-conviction disclosure was established by a 2014 UK Supreme Court case called Nunn. And what that case requires is that those seeking to prove their innocence and access exculpatory material that might be held by the police or the prosecution have to pinpoint the existence of that material, then explain why it affects the safety of their conviction. It's easy to see why in practice that doesn't really work, because in general, any exculpatory material that's been withheld from you is something that you're not going to know about. So how can you request it, let alone make the case for why it should be disclosed? Simple fact that really the only reliable way of uncovering disclosure failures is to get the police file and look through it and to see for any evidence that wasn't disclosed to the defence but should have been. And I want to talk about Louisiana again because interestingly that is exactly what people working on wrongful conviction cases do. So under the state's public records law, in any closed case, someone is able to access the district attorney file and the police file. And that means that they're able to go through and see any material that should have been disclosed. And the Innocence Project in New Orleans, they produced some statistics on this. And I think of the 43 exonerations in the state between 1990, of the 48 exonerations between 1990 and 2017, 43 of those have been dependent on that public records access. So, I do wonder how many more Andy Malkinsons we would find if we made it easier for those working on these kind of cases to access material held by the police and prosecution. And obviously the CCRC aren't really doing their job, so they do have statutory right of access, but they're not using it. So I definitely think that we need to broaden that right out. Just to conclude, there are plenty of other known failings in the case already. Max talked about the unlawful evidence destruction. There's also issues to do with the fairness of the lineups that were carried out in terms of the other individuals that were shown to the witnesses. And the prosecution, another failure, I think, is that the prosecution explained away the lack of any DNA evidence implicating Andy by using the very unscientific notion that he was somehow forensically aware and so had deliberately taken steps to ensure he didn't leave any trace. And that doesn't strike me as responsible prosecuting. However many failings that we know about already in Andy's case, there are now several reviews. There's the inquiry that the government have announced, as well as an IOPC investigation. CCRC are doing their own review. And I imagine that many other failings will surface. But it's already clear that Andy's wrongful conviction was a real catastrophe of justice. Robbed Andy of 2 decades of his life. It utterly failed the victim in this case. And it put public safety at risk as well. But to end on a slightly hopeful note, I just want to emphasize that it was not an unavoidable catastrophe. The failings that I've talked about were not aberrations of a system that's working really well. They're all the consequence of a system that invests way too much trust in the police and which allows juries to convict on the majority, divided juries effectively to convict on weak identification evidence, and a system which has a safety net that really doesn't offer any. It's not doing its job in terms of ensuring that those who are innocent get the chance to clear their name. So these are all things that can be changed with enough willpower and enough creativity. So I really hope that what Andy's case leads to is not just some tinkering with the system, but really a full overhaul of it. Thank you.
Got a little bit of time for questions. I can see online that Ian Kelsey's got his hand up, and I'm going to invite him, perhaps, if he's got a question, to type it into the chat box, and then we can have a look at that. Whilst I've asked him to do that, have we got any questions in the room? Yeah, hi.
Basis for the JR of the police.
I'm going to let James deal with that one. I'll see him spearheading it.
Yes, there were actually 2 judicial reviews against Greater Manchester Police, and they were both to do with their refusal to provide access to material. So the first request was quite a broad request for access to case files. They initially refused, we judicially reviewed them, and they decided to drop their opposition to it and allow us to see stuff. And then because of that, we found out about some of the non-disclosure of the case and requested even more material from them. And they gave us some stuff, but not everything. So, we had to JR them again. And, on the day that Andy's conviction was quashed, Greater Manchester Police did issue an apology. But I think the reason that apology rings so hollow for Andy is that up until very recently, they were fighting us tooth and nail over disclosure. So,
Yeah, I think what I'll add to that is it's really quite hard to describe how torturous the process was of getting disclosure in this case. And as James has already explained, and anybody that's ever practiced in JR will know, it is a very, very heavy weapon to have to pick up. It requires resource, it requires a great deal of preparation. And of course, it requires passing an extremely high threshold. And it is very interesting in Andrew Malkinson's case that at the 11th hour, the applications were not contested. But that feeds back into what I was saying earlier, is that if you're going to take these kind of cases seriously, you've just got to pursue every conceivable angle and avenue, and possibly even avenues that hadn't occurred to you, because if you take no for an answer, you'll be sitting down and shutting up at a very early stage of proceedings. Any other questions? See if I've got one from Ian here. Well, I'll read that. So Ian Kelsey's question, so it's not Ian, it's Robert Kay. I have a question about two non-DNA grounds which CCRC did not refer on and the CPS opposed, which the court did give leave to raise and eventually upheld. Do you have any thoughts on the CCRC and CPS opposing those brackets apparently well-founded grounds? And do you think the Court of Appeal would have been prepared to allow them had the DNA not satisfied them that Andrew Malkinson was factually innocent? Well, as I've already said, it was a source of real encouragement, if not relief to us, that the Court of Appeal went beyond ground one, which was the DNA ground, which the prosecution conceded. But it is a source of real anxiety to me that had the DNA evidence not been there, I personally don't believe we would have got ourselves back into Court of Appeal. And that is a source of real anxiety, because in one sense it was a providential intervention that it enabled us to discover that that DNA belonged to an identifiable person. But as I've already said, that's not what led to Andrew Malkinson being convicted in the first place. And it would be reasonable to observe that Edward Henry's very considerable skills has been brought fully to bear to ensure that leave was granted on those grounds, and ultimately that they were included in the Court of Appeal's determination that this was an unsafe conviction. So certainly that's my personal assessment. I think maybe you've got anything you want to add.
Yeah, I mean, I think, so in terms of the CCRC, as I said before, I was being very selective with the failings, and we can talk a lot more about what the CCRC did wrong in this case. When they finally referred the case in 2023, this year, they made the fresh DNA evidence the sort of primary ground of referral, and sort of half mentioned the non-disclosure grounds. They weren't able to say that this evidence didn't matter, but they were basically more conservative than the Court of Appeal and declined to make those standalone grounds of referral. And actually, they even refused to say that they were definitely non-disclosure. They sort of said, well, even though no one can recall it being disclosed and there's no record of it being disclosed, maybe it was disclosed, which kind of shows how spineless the CCRC are. And yeah, I mean, I think that all the reviews now in the inquiry, I really hope they look at that. And it just shows how sort of rotten the CCRC has become, I think.
So yeah, we do now have a question from Ian Kelsey, and remarks upon how fortunate we are that appeal exists, and I absolutely endorse that observation. It is a very unusual, if not unique, organisation in my experience, but goes on to observe, is it not the case that a real problem is a police won't accept they made a mistake, and that goes to what's being described as the establishment as a whole. I think what I would say about that is, and this gets a bit personal for a second, because I've always taken a view that you are sometimes at your strongest when you admit your vulnerability and your frailty. And I think that that is just as true for institutions as it is for individuals. And my own assessment of the English criminal justice process is it is one which likes to achieve certainty as quickly as possible. In other jurisdictions, a conviction is not finally confirmed until multiple avenues of appeal have been exhausted. And that really has never been the English way. In England, when you're convicted until the Court of Appeal says you're not convicted. And it can be very difficult to get into the court, and it can be very difficult to persuade the court that that is so. And when one reflects upon the mechanism by which the CCRC makes a referral, namely that in almost every case there has to have been a previously refused appeal or application for leave to appeal, that necessarily denotes that on a previous occasion that decision was wrong. And it may be, and it is the case in Andrew Malkinson's case, that when he had his initial appeal in 2006, perhaps very unfortunately, the whole focus of the appeal was, in my view, completely misdirected. And without getting into the nuts and bolts of it, it was all to do with potential contamination of forensic samples, which only came to light after the conviction. Nonetheless, that was a hearing of an appeal where it was deemed that the conviction was safe. And I would personally very strongly welcome all of the institutions that are involved in the criminal justice process just being a bit more candid about things, and where things have gone wrong, putting a hand up and saying, yes, that went wrong, because it's not kidding anybody to suggest that we have a perfect system of justice. We don't have a perfect system of justice. It is operated and administered by human beings, and human beings fail. And sometimes they fail through carelessness. Sometimes they fail by accident, but sometimes, unfortunately, they fail on purpose. But whatever the reason for the failing, I absolutely think that the institutions of the criminal justice process should be much quicker to say, yeah, we got it wrong here. Yeah, hi.
It kind of follows on that note. Certainly one of the things moving forward would be more candor from everything I've heard CCRC, but I suspect they would suggest we have limited funds. We don't want to open floodgates. And I don't know that that has any grist to it. What would, I think the point is how, moving forward, what needs to change at the CCRC, aside from a complete change of culture and thought?
I will actually appreciate James formally has a job title investigator, but he's been giving a lot of thought to this. I'm going to give way to him and let him deal with it.
Yeah, I think, as I mentioned before, I think the really key thing is accountability. I think when the CCRC first started, from all the accounts I've read, it was better. It had a sense of mission. It was referring more cases. And slowly over the years, it's become essentially a sort of part of the establishment. And an institution like this, which is about challenging wrongful convictions, has got to be willing to take on the police, take on the CPS, and take on the courts as well. And I think that the number one thing I would change would be making it more accountable, having some other mechanism, whether it's a tribunal or whatever, that applicants can go and say that the CCRC should have done this should pursue this line of inquiry, and continue to overturn the decision not to do that. But I think it's also about transparency. So we often find that if the CCRC has done some kind of investigation, maybe looked at some police files, or even they've met with the police on the case, even if it's a case that where we're alleging police misconduct, they won't share with us the disclosure that they've seen. They won't even tell us what was said in the meeting with the police. So that, I think, means that they are able to sort of shield themselves from a lot of scrutiny and get away with these poor decisions. I think the real possibility test, so the CCRC can only refer cases where it considers there's a real chance that the Court of Appeal will overturn a conviction. That could perhaps be changed, and the New Zealand CCRC, which was just set up, actually went for a very different test. Because what you really want is a CCRC that's completely independent from the Court of Appeal and isn't just constantly looking at what the court is doing and sort of only referring a case where it thinks the Court of Appeal won't turn it down. And the words real possibility, it's very hard to quantify that. But Lord Bingham, in a famous judgment, sort of said it can be less than a probability. But actually, when the CCRC refers a case, 70% of those cases then get those appeals are successful, which to me suggests that they're being way too conservative in the number of cases they're referring. So there's a few things there. There's obviously the Law Commissioner doing a review of the criminal appeals system, and hopefully we'll look at some of these institutional things, but they can't pin it all on funding. I'm convinced that if they had like triple their funding when they first considered Andy's case, they would have reached the exact same decision.
I got a question from Carol McCartney online. Was it the case DNA evidence retained in the forensic archive, which also contains evidence from cases pre-2012, which means that any other Andrew Malkinson's convicted since 2012 will be wholly reliant on the police obtaining that evidence? If relying on the national police, this would presumably be destroyed in your view.
Yeah, so when the Forensic Science Service was shut down and forensic science was effectively privatised and outsourced to individual companies, it's absolutely right that in terms of the storage of samples, that became the sole responsibility of the police, with the exception that they might have some kind of memorandum of understanding with the forensic provider about retaining certain bits of material. But yeah, the great thing about the Forensic Science Service is that it was another body, and they kept stuff separately, and so it meant that even if the police were weeding stuff and destroying stuff willy-nilly, you still had that chance that the forensic archive might have the material. And as Matt says, if everything had been destroyed, I think Andy would probably not be exonerated. So I think Carol's question is absolutely right to highlight that issue. And there needs to be a kind of central repository for all these kind of critical exhibits where the police, frankly, can't get their hands on them.
Question from Marion: why are wrongful conviction cases simply not given the attention needed quickly? Why legal experts are not able to intervene quickly or taken seriously? I mean, because the sheer number of people looking for help. I mean, and I'm sure this is true for Edward as well, in the aftermath of the appeal, have had direct approaches from prisoners, convicted persons, and you've only got to see the appeal mailbox to see the sheer quantity of people out there looking for help. And for anybody that's never been involved in a case at a post-conviction stage, it can be really easy to underestimate the magnitude of the task that is involved, because it's one thing preparing for trial, and it's another thing scrutinising what's gone wrong at a trial where you don't have the benefit of actually having been a participant in the proceedings. And of course, in Andrew's case, as time went by, you had new lawyers coming into the case, going out of the case. You've got matters being litigated and relitigated, and it's a bit like trying to follow the track of a vehicle or something that's been driven over 20 times. It's just an extraordinarily difficult task. And so the very short answer to that question is there just aren't enough lawyers out there with the time and resource to give every case like Andrew Malkinson the attention that it deserves. We had another question about help and assistance being made available to the wrongly convicted. And Jane Bigstaff commented at the outset about the widespread public shock, and I don't think it's overemphasizing it, outrage at the possibility that board and lodging might be deducted from any compensation payment to be made. But it's really reductive and naive, in my view, to see the experience that Andrew Malkinson had in purely financial terms, because in a very basic and obvious way, there's no sum in the money in the world that will give him back 17 years of his life. And not just 17 years of his life, but what it must be psychologically to sit in a prison cell day after day for 17 years with that burning sense of injustice. And I did remark to Andy in the aftermath of the appeal that perhaps in one way the really difficult bit for him starts now, because when you are being driven by that kind of fire and that goal and that determination, there can be a real moment of what now when it's all over. And I saw for myself out in New Orleans with an extraordinary exonerated man out there, John Thompson, right up close what it's like for the exonerated and wrongfully convicted, trying to rebuild their lives, put their lives back together. And absolutely, I take the view that there needs to be help and assistance lent to them over and above, I suppose, a simple question of compensation. And as anyone who knows anything about the compensation scheme in this country can tell you, it's not a simple question at all. And even if you get access to compensation under the statutory scheme, it is wildly inadequate to reflect the wrongfulness that happened here. So yeah, I absolutely endorse that inquiry. Yeah, I think that's all the questions online. Are there any more in the room?
May I ask you about the DNA, just so we can understand the whole scale of this, if you're able to tell us? I think you've told us two things so far, if I remember correctly. The first was that it was on her clothing.
Vest top.
A vest top, did you say? And the second was that it was considered to be evidentially significant.
Yeah.
What was it known at the time of the first trial? Was the scientist able to say what fluid the DNA was from? I mean, was it from semen or was it something else?
James is such an expert on the DNA side of the case that I'm gladly going to.
So yeah, the DNA on the vest top, the reason that the CPS regarded it as crime specific was because it was just above where the victim had suffered a biting injury to her nipple. And it was in an area that tested positive for amylase, which is a component of saliva. So the position in trial was that effectively no DNA other than the victims had come back on that sample. But then after trial, there was more sensitive testing that was done. It's actually done arranged by Greater Manchester Police as part of a nationwide retesting initiative called Operation Cube. The CCRC were made aware of that finding and yet didn't refer the case. And that, like I said before, even though all the kind of potential innocent sources of that DNA had been ruled out.
So I'm sorry to interrupt you, but can I just, so at the time of the first trial, Mr. Malkinson couldn't be ruled out specifically because they were saying it was just...
There was just a complete absence of anyone else's DNA.
It sounds like what you're saying, that there came a point because of the retesting where he could actually be ruled out.
Yeah.
When was that? A year?
2007.
2007.
So the police and CPS were aware of that.
And forgive me for interrupting you, but was it from that stage known that it was a profile that was capable of being matched to someone if they could find that someone?
Yeah, it was a searchable profile. The searches at the time that were done on the database didn't bring up any matches. The point is that this alternative suspect who's now been identified, his profile was uploaded in 2012, which is the year that the CCRC rejected Andy's case.
But even knowing what they must have known from 2007, there isn't then some sort of automatic running periodically against the database for the individual who can be identified to be identified if they can. Are you saying that's a thing that doesn't automatically?
It didn't happen with this sample. My understanding of the way the National DNA database works is that they're quite selective in which samples they upload permanently. So they're doing constant checks. So this was a partial DNA profile. It was capable of being matched to somebody, but they decided not to just keep it uploaded. What the CCRC could have done instead was arrange periodic searching. Every year they could do a search.
So they have a power to do that, but they didn't do it in this particular case. And across all these years when Mr. Malkinson was protesting his innocence, not just as many people do by simply speaking it, but by to the extent that he spent 10 years longer than he needed to in prison because he wouldn't admit what he did. Was there anybody on his behalf, a lawyer or some equivalent, requesting retesting who was ignored, or because he's simply in prison, did he not have anybody?
No, so in his first CCRC application, he was represented, and those lawyers asked the CCRC to do testing. CCRC has the resources and the access, in terms of access to samples, access to the National DNA Database, to have made those inquiries. They refused, and their reasoning was essentially, yes, it could be DNA from the attacker, but equally it could be DNA from some innocent source. And anyway, it's a very strong ID case. When we came to the case, we knew that simply asking the CCRC to do it again would not get us anywhere. We knew we had to get the testing done ourselves. So we then began this process, which, as Max said, there were a couple of forensic scientists who wrote a very helpful report on the new techniques of what testing could be done. That was able to persuade the police to allow us access to the remaining samples, and also the legal aid agency to fund the testing. And that testing showed not only that, again, that Andy could be ruled out of that profile on the desktop, but there were other areas on the victim's clothing and samples taken from the victim where, again, you had unknown male DNA, which couldn't have come from Andy. And that included under the fingernails on the hand she said she used to scratch her attacker.
And has that now been tested and identified as somebody's DNA, the fingernail?
So effectively, the man who's been arrested cannot be ruled out as a source of that. That's consistent with this profile.
Interesting. Thank you very much.
Right, I mean, that seems to be it online. I'm just going to do a last check. Yeah, I think we will wrap it up there. I want to thank everybody who's come in person today. I want to thank everybody who's dialed in to watch the lecture. I see, in fact, we've got Christophe Champon dialed in, so he's the DNA scientist who proved really absolutely instrumental in what James has just been discussing. But I hope that the takeaway for everybody is, first, as I acknowledged, unfortunately, Andrew Malkinson will be far from alone in having experienced a wrongful conviction like he has. But I hope that we've offered some pointers and guidance from the experience that we've gathered over the last few years as to what is required to take one of these cases on, and some of the changes to the system generally, which would be very welcome. But thank you very much all for coming.